Covid-19 has been declared as a pandemic by the WHO as well as a notified disaster by the Indian government. It has definitely sent shockwaves across the globe, has severely and significantly disturbed the supply chain globally in both domestic as well as international contracts. In such a scenario, what is important to ascertain first is whether Covid-19 would be construed as a force majeure event under the relevant clause. And for that, we may have to go back to the wordings of the force majeure event. In certain set of contracts, an epidemic or a pandemic may be specifically categorized as a force majeure event. And in that case, Covid-19 would definitely be considered as a force majeure event. There may be certain other generally worded force majeure clauses, which may say that any event or circumstances which was beyond the reasonable control of parties would be construed as force majeure, and therefore Covid-19 being a global health crisis would still be considered as a force majeure event. So once that is clearly established whether Covid-19 would be considered as a force majeure event under the relevant contract, we will then have to ascertain whether it's a question of fact and circumstances in each particular contract that the breach of performance of obligations of the relevant party was clearly and primarily caused due to the Covid-19. And if that is the case, there may be certain exceptions and certain flexibilities that may be given to the other party for performance of the obligations.